A moment to address your question, Judge Gomez Robledo, which was put to Myanmar. Please forgive if we also say something about it. You cited paragraph 163 of the court's judgment in the Pulp Mills case, which mentions the expectation that an applicant in a case will submit the relevant evidence to substantiate its claims, as the Gambia has done. The court continues, and I quote, "This does not mean, however, that the respondent should not cooperate in the provision of such evidence as may be in its possession that could assist the court in resolving the dispute submitted to it." And you then asked, Judge Gomez Robledo, quelles conséquences la Cour...
What consequences should the court draw from Myanmar's refusal to cooperate with the bodies tasked by the United Nations to investigate the facts relied upon by the Gambia for its allegations, including as concerns evidentiary value and inferences drawn from the application's evidence?
Now, we say that is a pertinent and important question. What consequences are to be drawn from a state's failure to cooperate? This question highlights the role of the United Nations bodies in the issues before the court in this case, in their fact-finding role. This question illuminates for us a truth that by its failure to cooperate at all with these bodies, by its failure, for example, to allow those UN bodies to carry out site visits or investigations, Myanmar has undermined its ability to challenge the probative value of the evidence generated by the FMM and other bodies. And it has also undermined its ability to challenge the inferences that those UN bodies have drawn from the facts that it has found, from the evidence it has collected, including the conclusion of the 2019 FFM report, namely, and I quote, "There is no reasonable conclusion to draw other than the inference of genocidal intent from the state's pattern of conduct." End of quote. Don't cooperate. It's pretty tough to challenge those words. Mr. President, I turn to the standard of proof. Now, the standard of proof we've relied upon is precisely the one that the court has told us to rely on in other cases under the 1948 Convention. The proof of the facts has to be fully convincing. You have to be fully convinced that the Rohingya are a group, and I have no doubt that by now you are. You have to be fully convinced that members of the group have been killed, subjected to serious bodily or mental harm, subjected to conditions of life calculated to bring about its physical destruction in whole or in part, or subjected to measures intended to prevent births within the group. It would be odd if by now you are not fully conclusive on that issue. You saw and heard the three witnesses for yourselves. And you have to be fully convinced that the only reasonable inference to be drawn from the evidence and the conduct it discloses is that Myanmar intended to destroy a part of the Rohingya group. The UN bodies are so convinced. Professor Newton is so convinced, as you heard. So that raises the question, no doubt, in your minds, what does fully convinced mean? It means fully convinced. It does not mean, and the court has never said it means, beyond a reasonable doubt. That latter standard is a common law standard, and it's a criminal standard. And this is not a common law court, and this is not a criminal court. The court applies international law, and the international standard to be applied is fully convincing. Ayant pleine force probante. This is the moment to address a question put by Judge Hamoud. Sir, you have noted an apparent contradiction in the position adopted by Myanmar. On the one hand, it recognises that the regimes for individual responsibility and state responsibility are distinct. On the other hand, it goes on to say there's no distinction between a criminal standard of proof and a civil state responsibility standard of proof. That is a contradiction. They are wrong. There is a distinction. First, this court's standard of fully conclusive, as I've said, is not the same as beyond reasonable doubt. Myanmar says they're comparable. Well, what does comparable mean? Well, I checked the Oxford English Dictionary. Comparable means able to be compared. So sure, you can compare the two different standards, but it doesn't mean, the word comparable, that they are the same. They're not the same. In assessing the circumstantial evidence that establishes the genocidal intent as the only reasonable inference, this court asks itself whether the evidence is fully conclusive. A second difference, sir, in relation to your question, this court is not deciding whether any individual is guilty of the crime of genocide and whether they should be deprived of their liberty for that reason. And that necessarily means that the degree of scrutiny will not be the same, will not be as acute. The consequences will not be as dramatic. No one's going to jail because of the judgment you give. Third difference, and relatedly, this court is not asked to form a view as to whether any particular individual had at a particular moment of time a genocidal intent. No, that's not what you're doing. You have to form a view as to whether a state of mind, a genocidal intent, may be attributed to a state by reference to the actions of its organs. In this case, its military forces. The intent of an individual is not the same thing as the intent of a state. And fourth, and again related to this last point, it is not a precondition of state responsibility for genocide that there should be a finding that any person acting on behalf of the state should have committed the crime of genocide according to a beyond reasonable doubt standard, as Myanmar says, or indeed any other standard. Your case law adopts a very different approach. By way of example, this court can determine that a state has been engaged in an illegal use of force without determining that an individual crime of aggression has occurred. That's what you did in the Democratic Republic of Congo versus Uganda. And relatedly, in the Corfu Channel case, the court found that the laying of a minefield, and I quote, could not have been accomplished without the knowledge of the Albanian government, end of quote. In other words, the court formed a view as to the knowledge of Albania. It examined the state of mind of a state, an incorporeal entity, and it did so explicitly by means of indirect evidence, proof drawn from inferences of fact. The court went through this exercise without having established or even being informed about a view on the role or state of mind of any individual or the criminal liability of any person. In short, in its practice, the court has accepted that assessing the state of mind of an individual, the knowledge, whether it's knowledge or intent, is a distinct exercise from assessing the mind of a state. If this court can determine that a state is responsible for the consequences of laying a minefield, it can determine that a state is responsible for the consequences of acts by its armed forces that amount to genocide. And finally, sir, in relation to your important question, which I found very helpful, there is a difference of process in determining whether the applicable standard is met. In the criminal context, there will be weeks, months, years of witness testimony. This court applies its own approach, and it doesn't follow that approach, and consequences must flow from that. So what does fully convinced mean? What does ayant pleine force probante mean? I appreciate that people like me who are trained in the common law sometimes have real difficulty in grappling with civil law or other standards. I sit on the Court of Arbitration for Sport, and there the applicable standard of proof is derived from a Swiss law standard, and for an English barrister it's pretty odd. It's a standard of conviction intime, sometimes translated, not perfectly, as comfortable satisfaction. Well, the first time I encountered this standard, about 13 years ago, I must confess I had some difficulty because I'd not encountered it. I'm trained in the common law, and so my brain is totally malformed by these common law conceptions. But then a Swiss lawyer helpfully explained conviction intime to me as follows. If you wake up in the morning and you're still worrying about whether the standard of conviction intime has been met, then it has not been met. When it's met, you don't worry about it. The fully convinced standard is not what makes you comfortable when you wake up in the morning, but neither is it susceptible to a mechanical approach. It is for each of you, individually, guardians of the Genocide Convention, to form a view as to whether you personally, in exercise of your judicial function and intellectual capacities, are fully convinced by the evidence in relation to a particular factual matter. It means more than partly convinced, and it means less than totally certain. It's a matter of individual appreciation, and each of you individually will form a view as to whether you are fully convinced that the only reasonable inference from the pattern of conduct, which we say is irrefutably established, is that Myanmar intended to destroy the Rohingya group. And then your individual views will be totted up, added up, and a collective view will emerge. And that is a numbers game. So let me here address Judge Charlesworth's first question, which was for the Gambia. You noted, Judge, that the FFM applied a reasonable grounds standard of proof in making its factual determinations back in 2018 and then 2019, and that the mission described this as lower than that required in criminal proceedings. And you've asked now about the consequence of the application of that standard as compared to the court's fully convinced standard for how the court should approach the fact-finding mission's evidence. Another pertinent question. First off, in any case, goes without saying, but it needs to be said, it's always going to be for the court as a collective to decide whether it is fully convinced by the relevant evidence. Even if the FFM had explicitly applied the fully convinced standard, we would expect the court to go through its own assessment and reach its own conclusions. You're not bound, as such, by factual findings of the FMM, whatever standard it applies, and however credible and authoritative it is, and we say it is both. The standard it applied was that to which it was directed in its terms of reference, in accordance with the practice of UN fact-finding bodies. Accordingly, the difference of standard is, in practical terms, of no real consequence with regard to the exercise you're going to have to go through. That's because you're going to have to go through your own assessment of the facts that were found by the FFM. And doing so, you will form your own view as to how much reliance you feel able to place on the FFM reports. No doubt you'll have regard to the fact the FFM is an independent body, that it's acting pursuant to a mandate given to it by the UN, that it is led by individuals with strong credentials, and that it has applied the stringent UN fact-finding standards that have been in place since 2015. No doubt you'll have regard to the fact that the FFM's mandate did not prevent it from concluding that the evidence reached a higher standard. The court standard, when it concluded, and I quote, that there is no reasonable conclusion to draw other than the inference of genocidal intent from the state's pattern of conduct. You might also have regard to the fact that the factual findings of the FFM have been reached and then acted upon by the High Commissioner for Human Rights, by the Human Rights Council, and by the UN General Assembly. And you might also have regard to the additional evidence that has been put before you, gathered and put before you, which confirms and corroborates the totality of the FFM's findings of facts and its conclusions. And you might have regard to the consequences, including for future work by UN bodies, of this court concluding that the work of the FFM somehow falls short of the court standards. You might have regard to the fact that neither the work nor the conclusions have been challenged by any other state except for Myanmar, and have been received as authoritative across the world. Mr. Reichler will say more about this. But beyond this, you've also been provided with a means to assist in forming your view as to the weight to be given to the FFM's factual findings. 3 witnesses appeared before you to tell their stories and answer their questions, including your questions. And as you listen to what they said in this great hall of justice, did you hear anything that would allow even a shadow of doubt to form in your mind, Judge Charlesworth, as to the conclusions of the FFM reports, on the experiences they went through, and on the matters they addressed and told you about? Were you or were you not fully convinced by witness MN's account of mass execution? Were you or were you not fully convinced by witness NJ's account of having her child torn from her and thrown into a fire before her own eyes? Were you or were you not fully convinced by her testimony about being gang raped? Were you or were you not fully convinced of witness MS's account of his daughter being shot dead as she crossed a river seeking to escape? Did you see or hear any disconnect between these 3 accounts and the facts reported by the FFM? Did you see or hear any disconnect between these accounts and the explanation given by Professor Newton as to why such acts can never be characterized as counterinsurgency and why they are not ethnic cleansing alone? Having all of that evidence and having heard the witnesses, can you say that you are not fully convinced that the acts they described can only be explained as reflecting the intention of the Tatmadaw and Myanmar to destroy them because they happen to be part of a group that has been persecuted and vilified for their race and their religion for decades? Mr. President, members of the court, I turn to the conclusions. By Article 9, the drafters of the 1948 Convention explicitly gave to this court the mandate to resolve disputes relating to the responsibility of a state for genocide. That's what the text says. That direction, that mandate, imposes a burden on all of us in this great hall of justice as we discharge the obligations that fall upon us in relation to the matters of fact and law that arise with this case. And all of us, surely, will have been deeply affected by all the accounts we heard of the witnesses who've spoken in this great hall of justice. But none of us will wish to shirk those responsibilities. At a time when the idea of a rules-based international system faces acute challenge, the weight of those responsibilities may feel very great or perhaps even insurmountable. And that is what makes, at this moment in time, the 1948 Convention so very important. The system that emerged around the Convention has been catalysed in this case in a way that did not happen in the Bosnia or Croatia cases, which did not have the benefit of a deep, deep dive, a UN exercise into establishing the facts, including thousands of witness statements, generated by an effective, timely, and it has to be said, well-functioning United Nations system. That system may not have prevented the genocide, but it has offered a means to secure accountability for it. And the International Court of Justice, as the principal judicial organ of the United Nations, has been given the central role in securing such accountability. To sum up, the real issue in this case is intent. Myanmar says the intent is counterinsurgency. The Gambia says the intent is the destruction of a group in whole or in part. And so does everyone else who's looked at these issues and facts. The eyes of the world are upon you. Blink, and the 1948 Convention is dead. Mr. President, members of the Court, I thank you for your attention, and I invite